various attorneys who will be taking questions for us. In just a moment, I'm going to ask them to introduce each of themselves. Marilee, do you want to start?
Sure. I'm the owner of Clark Law Firm in Scottsdale. I also serve as chancellor for the Desert Southwest Annual Conference, which chancellor means attorney, and that's of the United Methodist Church. And I had the pleasure when I was a student at University of Wisconsin Law School to hear Ruth Bader Ginsburg speak in person at the National Women and the Law Conference.
Thank you. Gerald, will you introduce yourself, please?
Thank you. I am the owner of the law office of Gerald P. Richard II. I primarily practice criminal law. I am also a pastor of Prince Chapel AME Church, which is located in Tucson, Arizona. I have served on a number of different committees and organizations. I formerly was prosecutor for the Maricopa County Attorney's Office, primarily prosecuted street gangs and occult criminal activity, and also worked for Phoenix Police Department for 21 years as the director. I've been with the Attorney General's Office as Special Policy Advisor for Law Enforcement. I've run for County Attorney, and I've also served with the Department of Justice and helped to work on the after action assessment for Ferguson, Missouri, as well as worked on Salinas Police Department in California as far as the issues they were dealing with.
Thank you. Paul, will you tell us a little bit about yourself?
Yes, thank you. Good evening. I'm a retired attorney. I started my career with Legal Aid in Tolleson, Arizona, spent a couple of years there, and then I worked for the state of Arizona in a variety of positions for the next 20 some odd years. And I spent the last 10 years of my career with the United States Attorney's Office, represented the United States in civil matters in federal court.
Thank you. And your moderators this evening, I have several people who are going to be helping me prepare some questions for this incredible panel we have. First, we have Reverend Khalif Smith, pastor at the First UMC Church in Mesa, and is chair of the Desert Southwest Race Coalition. Next, we have Reverend Katie Sexton, executive director of the Arizona Faith Network. Billy Fidlin, Director of Outreach and Justice for the Desert Southwest Conference of the United Methodist Church. And me, I'm Jerry Hills, and I am the chair of the Desert Southwest Conference Board of Church and Society. So let's get right into the evening, and I'm going to turn it over to Billy for the first question.
Thank you so much, Jerry. All right, friends. Well, you're on the stage now to answer some questions that we put together for you. For full transparency, all attorneys did receive these questions ahead of time, and so they've had some time to ponder them. The first question is, which of Justice Ginsburg's opinions may be key to shaping future cases, and why? Who'd like to start?
I'd be happy to start. First, I'm really happy to have been asked in order to be on this panel. A lot of times I'm on panels that deal with police issues, community relations, things of that sort. So this one actually was fun as far as taking a look at Justice Ginsburg. And for me, it was the United States versus Virginia with the Virginia Military Institute that primarily was a victory for gender equality. The way that I saw it was that it was not only an issue with regards to addressing issues of archaic gender generalization issues, such as most women are this and most women are that, but it also addresses single sex education distraction issues that they tried to bring up. It went back to include Brown versus Board of Education, and also the denial of opportunities for women, more importantly, under the equal protection portion of the Constitution. And so as a result, when I look at it, it's far reaching because it addresses equality for all. It's a case that when I thought about it, I kept thinking to myself how 6 months before I turned 18, the draft stopped. And should the draft come back this time as a result of this case, that will include women. That will include our daughters. And a lot of people don't think about that. So when you start taking a look at how you apply that to LGBTQ issues, how you apply it to individuals as far as racial injustice, what the case says to me is that it depends on the individual and what the individual can do and how opportunities should be available to them at every level. So it's far reaching for me in that sense.
Anyone else? Yeah, Paul, go ahead.
Well, there are a couple of decisions of hers that she was involved in that stick out to me in the area of criminal sentencing that I want to talk a little bit about. And the first decision it has to do with sentencing guidelines that judges use in federal court. Up until 2005, there were sentencing guidelines that judges looked at and had to adhere to. They were required to follow when it came to sentencing individuals for federal crimes in federal court. And the guidelines said that judges were supposed to give positive consideration to a variety of factors and negative consideration to a variety of other factors. And there's a formula and come out with a range of a sentence that judges were required to follow. They didn't have any discretion to go beyond those boundaries. In 2005, though, Justice Ginsburg was the key swing vote in the decision of United States versus Booker, which said that those guidelines were no longer to be considered mandatory if they were advisory. The judges were required to look at them and consider them, but they didn't. But they no longer were required to stay within those boundaries, and which was a significant change in the law, gave judges greater discretion. And just a couple of years later, Justice Ginsburg wrote the opinion in a case called Kimbrough versus the United States, which dealt with sentencing for distribution and sale of cocaine. Under federal law and under the federal sentencing guidelines, there is a disparity. The sentencing for distribution of cocaine, crack cocaine, was 100 times greater than the sentence you could get for powder cocaine. And Justice Ginsburg wrote the decision that said there was a judge who said that huge discrepancy didn't make any sense, and so this judge sentenced a defendant below for crack cocaine. He sentenced him below the guidelines, the federal guidelines, because he thought that 100-to-1 disparity was just so outrageous. And Justice Ginsburg and the Supreme Court concluded, yes, that was permissible to do that, to go outside those sentencing guidelines in something that had such a disparate impact. And that case has been cited by a number of by thousands of defendants saying, hey, the judges can in fact go lower than the guidelines. I guess it's a real important decision for judicial discretion when it comes to sentencing.
I'd like to pick up from the first point about the U.S. versus Virginia case and gender discrimination. When Ruth Bader Ginsburg passed away, President Obama made a statement talking about gender discrimination and was praising her, of course. And he says it has real consequences for all of us. It's about who we are and who we can be. And I think following up on that, the 2007 case of Ledbetter versus Goodyear Tire and Rubber Company was very important because it exposed the wage gap. There, Lily Ledbetter was a supervisor, equal and had equal qualifications to, the male supervisors in the company, yet she was unaware of this. When she was reaching retirement age and was calculating what she would get for her retirement benefits, she discovered that she was making significantly less than them. And then the matter was picked up. She was represented, but she lost at the US Supreme Court case because she had a statute of limitations problem. The court concluded she had not raised her issue soon enough, to which, of course, most would reason, hey, she didn't know about it until she had approached her retirement years. So in that particular case, that's one of the stellar dissents written by Ruth Bader Ginsburg, where she went to the extra effort of not only doing her very scholarly dissent, which was fairly scathing, but also she did one that was in plain English, which she actually read from the bench. And that's unusual, or it was unusual for her to do that. I did have the good fortune to hear Lily Ledbetter speak in Phoenix when she came to town to talk about her case and the anniversary of that case. And what happened thereafter was that dissent caused Congress to pass a law that then was able to fix the problem that had been identified in the dissent. And there, Ruth Bader Ginsburg even worked with President Obama, and that was actually the first law that he signed as president. I'd also make mention of the Olmstead case in 1999, and that gave protections to mentally disabled persons. So I think that's important for that reason.
Yeah, I agree. Jerry, I know you're up next.
Yes, thank you. So Gloria Steinem recently said that the question of the Supreme Court was always, did they make the right decision? With Justice Ginsburg, you could trust the right decision was made. Do you agree or disagree, and why? Paul, why don't we start with you this time?
Okay. In general, I think that's true. I agree with that because I support the same issues that Justice Ginsburg championed, such as equal protection under the law, gender equality, access to competent representation, opposition to the death penalty, limitations on sentencing, and a myriad of other issues. So as a result, I agree that Justice Ginsburg generally voted the right way, but that's not always true. There are a couple of cases where not only do I disagree with her, I think she's just wrong. And those are in the areas of tribal sovereignty. In 1997, she wrote the majority opinion in the case of Strait versus A1 contractors against tribal jurisdiction over tribal-owned land on a reservation. There was an automobile accident that occurred on a state right-of-way on a state road that went through the reservation, and the crash. And Justice Ginsburg reasoned that the state right-of-way on which the crash occurred rendered the tribal-owned land equivalent to non-Indian land. And furthermore, that because the victim of the accident was a non-tribal member, that it would be unfair to bring that person into a tribal court, an unfamiliar court. So the Supreme Court, her decision was that the tribe did not have jurisdiction in that situation over that event, and that was a decision that was criticized by scholars of Indian law. And another decision that she wrote in 2005, which was she called this decision the one that she regretted more than any other decision that she made in court. And that is the city of Sherrill versus Oneida Indian Nation of New York. And they concluded that the court concluded that the Oneida Indian Nation could not revive its ancient sovereignty over its historic land. It had occupied land in New York, the state of New York, and had left the state of New York, and then came back and 200 years later purchased land that they had originally lived in, decades, couple of hundred years earlier. and attempted to assert sovereignty over that land, their own land that they had repurchased. And the Supreme Court, and Justice Ginsburg wrote the decision, said that courts or that the tribes cannot reestablish sovereignty over land under these circumstances, land that they had occupied historically. So, and since that decision, there have been courts that have used that, relied on that to extinguish Native American land claims. So again, that's a decision that maybe she didn't get right, and I think she acknowledged that she regretted that decision.
Thank you. Gerald?
Looks like Mary Lee wanted to say something.
Oh, okay. Mary Lee, we'll go to you.
Well, I just wanted to sort of defend Justice Ginsburg a bit because, of course, when we refer to her fine decisions and her fine dissents, we must always remember that they were not solely hers, that she had to reach a consensus with others to come to a conclusion that might be the majority of the plurality or the plurality. And so she had to work with the other justices. Those that she wrote, of course, she felt strongly about, and it's well known that she had the strong work ethic, and she would work until late into the hours of even the wee hours of the morning to get things right. She was very perfectionistic. So certainly she gave everything her best, which is a model that we should all try to strive to follow. But yes, she was human, and humans do sometimes regret things that they have done.
Thank
I
you.
have to agree with both of my colleagues. Just as simple as that.
Okay. I guess we'll move on to the next question.
And that one is mine. Good evening, everyone. Thanks for being here. We know RBG as nicknamed as Notorious RBG in a lot of our culture. And so we know she was a huge leader for folks. And so I'm wondering, is there a danger in leaders, organizations holding a justice in such esteem that they would not question that an opinion or decision that they rule in because it came from their favored justice? Or have we become too cynical?
Well, I think that there's always a danger when you hold someone in such esteem that you never question them. I just, the only person that seemed to have the ultimate wisdom here on earth was King Solomon. And people would come from miles around in order to hear what he had to say. However, when we look at, and I think it was said a little earlier by Mary Lee, when we look at it at individuals, we know that we're all human. We all make mistakes, and that includes judges. And I've been before a lot of them who have made some mistakes. So we give the respect that we should to those individuals, especially those that, like Mary Lee said, work so diligently in order to try to see if they can find the right answer based on the law and based on the facts. But at the same time, it's important that we make sure that we continue to have those layers that we do, that individuals are still able to appeal, that we can get a new and fresh set of eyes on those issues. And then sometimes have multiple judges, as we do with the Supreme Court and the Court of Appeals, be able to discuss and analyze the facts together so that hopefully they can get it right.
Paul, Mary Lee?
Yeah, I agree with what Gerald just said. And I think that, to me, one of the dangers or the real danger of not questioning a decision or opinion from a favored justice, as a layperson, we really abdicate our own ability to form our own opinion. If we just rely on someone, even a trusted, highly respected individual, and simply follow or agree with or adopt their opinions, we've abdicated a responsibility for ourselves to understand what the issue is and think it through and really arrive at our own decisions. So I think that's just a cautionary tale that as much as we may respect someone, we really have an obligation to understand an issue and kind of reach our own opinion with guidance from trusted advisors.
In line with the topic for this evening, I would like to end the answers on this question with pointing out that Justice Ginsburg, though, was, I think, heads and shoulders above some of her colleagues. And I think even they recognized that. The Chief Justice's statement when she passed and how they respected her by putting her in the rotunda. She certainly, if not infallible, certainly had hit a very high standard for her work on behalf of others and trying to guide the United States in the direction that she thought would be best for all of us.
Great. Yes, thank you.
Well, it sounds like you have some pretty high esteem, at least respect for Justice Ginsburg, each of you. And again, thank you for being here tonight. I appreciate this conversation. My question is kind of loaded. One part of it is, what is your overall opinion of Justice Ginsburg? And what characteristics did she have that led you to this opinion? And does this influence your practice of law or the way that you view law in general? And how do you come to this conclusion? Or in what ways does it affect your view of the law?
I can start on this one. I think that her very first gender discrimination case was very creative, and it in fact came at the case from the standpoint of the representation of a male, showing how that male who wanted to care for his ill mother was being discriminated against by not getting the same government benefits that a female son or a female daughter, obviously a daughter would be female, but a female would have received caring for a family member. So that creativity, I think, caused the Supreme Court justices to think twice because they could maybe more identify with a male plaintiff. And that sort of then helped her in crafting some of her future cases, which she did through the ACLU. I think I try to be creative when I come up with theories for my cases. So that was a model that I've gone and used in the past for my practice of law. I think she's also a model for women lawyers. She was not only a judge and then prior to that a professor, but she also was a mother and she was a wife, and she did those parts of her life with fine work-life balance. She certainly knew her strengths and weaknesses. So she wasn't a good cook, but she married a good cook. And he was a fine tax attorney himself in his own right. So she had the intellectual stimulation that she needed. So they were a fine match. And they produced fine adult children. So I've always considered her a role model on the human side, the personal side also.
Thank you.
And I agree with that. I find her a role model on the personal side as well that also affects how my practice of law, and that is her collegiality, her deep friendship with Justice Scalia. People on different ends of the spectrum were very close friends and spent a lot of time together, and that type of collegial attitude is very important. Was very important to me in my practice to make sure that I treated all opposing counsel, everyone that I encountered, tried to treat with respect and collegiality, and frankly, that always worked to my benefit. No matter how the other individual acted, if they were did not reciprocate in that way, it still was definitely the right way to deal with people, and as I said, worked to my benefit. And that was a lesson from Justices Ginsburg and Scalia.
Well, in my opinion, Justice Ginsburg never forgot from where she came from. And because she never forgot where she came from, she was able to identify the injustices and to balance those facts and the law in such a way in order to get her point across. It's interesting. As an attorney, I found myself where, being from the south side of Chicago, especially prosecuting, I was able to raise issues with criminal defense attorneys at the time that made them think twice when they would come before me and say, well, you know, this kid, they're from South Phoenix, and this kid, you know, they went to this school, and this kid, and I would turn it right back around him. I said, where were you from? Well, I was from wherever it was in Philadelphia. I said, and did you also grow up and drink? Oh, yeah, sure. But did you ever go inside somebody's house and pour black paint all over their white rug and all their furniture? No. So what do you think I should do now? And I would always think of it from the other side before I came in and extended a plea offer. I found myself doing the same thing with the police department. Didn't forget where I came from. All the marches out there. Believe it or not, I used to have hair, a lot of it. And I used to march too. And I knew how I felt when I saw police officers. And as a criminal defense attorney, I find it as well, remembering where I came from, being able to ask those questions that really get to the crux of where the problem lies. And sometimes it's not just in the courtroom, but it's beyond that. What I like about her relationship with Scalia was I've taught a number of classes on leadership through Northern Arizona University. And I would always use this when I would chair different organizations, even as director, because a lot of people didn't question you when you're at the level of assistant chief. But I would always tell somebody, I need a no person. I need someone to keep me balanced. I need someone to make me think about it again. And that's what I saw with Scalia and Ginsburg. They provided that balance with one another, and they knew it. And they knew that it made them better as justices. If they knew that it was going to make the law better for our country. And so that's how I saw it.
Well, you mentioned a key word, Gerald. You said balance. And we now know that her seat has been filled on the court. Do you think, considering what we believe to be how the Supreme Court may rule in the future, do you think that Ginsburg would have been in favor of increasing the number of justices on the court, especially as how that could be, viewed politically? What say you?
I don't think so. I believe that she would have hoped that her colleagues would give credence to the precedents that have already been set, those that have already been established. But it's interesting because when I look at Kagan, Sotomayor, and Ginsburg, Sotomayor, she was like Ginsburg in a lot of ways as far as she didn't let you forget where she came from. Whereas Kagan, she may have written like Ginsburg, but her ideological way of presenting it was a little bit different. Her idea, if you understand what I'm trying to say to you, it's almost like you have somebody, and I got to go back to civil rights, somebody who goes through civil rights and they march and they get the affirmative action passed and everything else. And you get a kid that comes behind them 2 generations later saying, I don't want to be brought in under affirmative action. It's like, do you know what we went through in order to get you to get in? Oh, no, I don't need that anymore. I'm fine. And you're thinking to yourself, if you only knew your past, knew what happened in the past to get you to where you are now, it's not to take anything away from you, but it's to let you know that a lot of us went through a lot so that you could have the benefits you have today. So I don't think she would have. I would hope. I think that she would want to say, "I trust the court to do the right thing." And I tell you what's really ironic, Billy, was um, Thomas was the one who swore in Barrett. Thomas was supposed to have been the one to take Thurgood Marshall's place, and Barrett was the one to supposedly take Ginsburg's place. And they are so opposite. They are just so opposite.
Paul or Mary Lee, your thoughts?
Well, I actually have a quote from Justice Ginsburg herself. She was interviewed by NPR on July 24, 2019, and she said, "If anything would make the court look partisan, it would be that. One side saying, when we're in power, we're going to enlarge the number of judges so we would have more people who would vote the way we want them to. That impairs the idea of an independent judiciary," she said.
Paul?
I agree with what Justice Ginsburg said.
Okay.
I concur.
I appreciate that, Khalid.
But this wouldn't be the first time that the court has been increased, right? I mean, it's historically the precedent is that the court has been increased, the number of justices.
You know, there was NPR had some different individuals on, different experts talking about which party actually increased the courts, and it was under Republicans, not Democrats. And I'm glad, Mary Lee, I want to thank you for bringing out that statement from Ginsburg. It's just, you know, I was just coming from the gut, so.
I think we would have all come from the same gut.
So there is something called the Ginsburg Rule, and which she operated under. No previews, no hints, but yet she made her views clear in terms of how she felt on women's issues, among other things. At her nominations hearing, so how do you feel about the recent nomination hearings? Was Judge Barrett dodging questions, or did she answer by a non-answer appropriately? Who'd like to start?
Well, I'll start. I agree with the Ginsburg rule that a justice or that a nominee should not preview or provide a hint as to how they would rule in a particular decision on a particular issue. And I think as to now Justice Barrett, there were enough comments that she had made in her writing, in her speaking, in her personal life, you know, as a judge, as a professor, just as an individual, that there were hints galore out there, or statements, comments or things that she had done that people viewed as hints as to how she was going to vote. And so, you know, she didn't have an opportunity to simply say, "Yeah, I am giving you no hint as to what I'm going to do," because the hints were there, and she had to deal with those in her hearings. For example, there have been 2 decisions issued by the Supreme Court in the past few years on the Affordable Care Act, both of which supported the Affordable Care Act, both of which were written by Chief Justice Roberts, and both of which were criticized by Justice Barrett. And so she was questioned at her hearing and asked, "Well, you know, what are you going to? Doesn't that suggest that you are going to vote, you know, against the ACA?" And there's a new case, Texas versus U.S., that's going to be argued on November 10th in front of Justice Barrett. So she will have an opportunity to vote on now the 3rd case attempting to get rid of the ACA. And so she was asked if her previous writings that were critical of the ACA would affect her decision. And she responded, I think that your concern is that because I critiqued the statutory reasoning, that I'm hostile to the ACA, and that because I'm hostile to the ACA, I would decide a case a particular way. She added, I'm not hostile to the ACA. I'm not hostile to any statute that you pass. So my point being, she has had to address those what people consider to be hints or clues how she might act, and then give her response to that, and people will then have to evaluate what her response is. But I don't think she's been able to escape her writings, and has had to address those.
Anyone else who'd like to follow up with that?
I think that Justice Ginsburg, as a nominee, was willing to answer some questions about certain laws and interpretations and approaches. But you're correct that, in fact, for the most part, her position was you can't give hints, you can't tip your hand, because, as she said, each case is decided on its own facts based upon the applicable law. So to that extent, I guess the recent nomination process was in line with that.
I concur with what both Paul and Mary Lee have said, but I also look at it. This was a little different than other hearings for individuals who have been nominated. I can understand that there was a lot of pressure here to try to get her one way or the other, in light of the fact that this was being pushed through the way that it was. And the last thing she wanted to do was to get caught in a situation like Kavanaugh, where she was fighting for her life. And so by following the Ginsburg rule, I'm not going to tell you how I'm going to rule. And I think it's wise, because you really don't know. You may have an inclination of how you might rule, but until you're sitting down with the other eight justices in order to come up with a decision and listen to the facts as they may swing it. They may swing it in a completely different way. That's what happened in the case of Muhammad Ali. They were dead set on sending him away. And it was a clerk that actually came in to try to explain what was going on, and they went the other way. So it really depends.
Thank you.
So our next question, did the actions of Justice Ginsburg as a woman's right advocate or her role on the Supreme Court have an ongoing effect on society, and how so?
In my opinion, it was both. I love the way that Mary Lee was able to bring in all of the different characteristics outside of the bench, and to let those listeners tonight know that here was an individual that was complete, and she did the work that she needed to do as far as a women's rights advocate, and what that did was create the foundation that was necessary to analyze the facts in the law and presented it to judges and justices, and later even in the pleadings and that she had, as well as the arguments that she had to make. But her life experiences gave her the understanding of how to convince others who didn't understand a woman's plight in the system of inequality. And she did that really good. And especially by being 5 feet tall, 100 pounds, everybody had to listen. My father used to say, dynamite comes in small packages, and if you mess with it the wrong way, it's going to blow your head off. So
Yes.
that was Ginsburg.
Haven't mentioned yet that she founded the ACLU Women's Right Project, and that's what she really did for the bulk of her law-changing legal practice, so to speak, where she would take forth those issues that were based upon constitutional matters and the gender discrimination in particular. And it wasn't just women's rights, of course, she was also going to show everyone that it's also men's rights and people's rights. So that was certainly the high point of her practice before she was on the US Supreme Court. But again, we've talked a lot about what she did on the US Supreme Court, and certainly that's when she had the most visible decision-making powers, and where she really was able to make definite decisions or lead decisions that gave the law of this land some guidance toward moving things forward.
She's been described as for women, the most important legal advocate in American history. And Justice Scalia called her the leading and very successful litigator of women's rights, the Thurgood Marshall of that cause. So that's for her activities, as a litigator prior to joining the court. So and I think Marilee has done an excellent job of describing and summarizing, her role prior to coming to the court, and then what she was able to do on the Supreme Court, just in so many different areas, as writer of a decision or the writer of a dissent, as in the Lilly Ledbetter case that Marilee described to us, that resulted in a change of the law to fix an error. In so many areas, of not writing the decision, then being a mover, being a critical vote on a close call. She really has had an impact in American society in so many ways. So I think Gerald had it right that she has really affected American society, both for her days as a litigator and as well as for her time on the court.
Thank you.
Awesome. Really, really good discussion. As a clergy person, I can relate to the next question, right? Oftentimes we, as people who are in the public sphere, are told that we are not to give our opinions out publicly about certain individuals, about certain politics, and so on and so forth. And as lawyers, I'm sure that you can probably attest to that as well. In a recent interview, Ginsburg didn't hide her contempt for Trump, saying, "I can't imagine what the country would be with Donald Trump as our president." And that her late husband would have said it was time for us to move to New Zealand. He has no consistency about him. He says whatever comes into his head at the moment. He really has no ego, or he really has an ego. How has he gotten away with not turning over his tax returns? The press seems to be very gentle with him on that. She also called him a faker. But to be fair, she came back and apologized, right? Or made some type of remark after that. And that was, she says, "On reflection, my recent remarks in response to press inquiries were ill-advised, and I regret making them." Ginsburg said in a statement, "Judges should avoid commenting on a candidate for public office. In the future, I will be more circumspect." And so NPR, Nina Totenberg, commented that Ginsburg is the first she could remember in modern times to publicly criticize a presidential candidate. Her words. What are your thoughts about this? Ginsburg was very experienced, and my guess is she knew her words would bring backlash. Was it strategy to make them and later apologize? Was it a misstep? And what role does a justice have, and are they supposed to be forever silent on public issues?
I think that everything she did was intentional. She was a very deliberate person. So I think her comments were intentional. I think that she probably intended from the outset to do an apology. The part where I would find a little flaw on her part is that the comments about the tax returns would be in the area where she might be as a decision maker in the future. So this was, of course, before he was even president, but we know now at least that yes, he continued to withhold those tax returns all through his presidency, and that this is something where the U.S. Supreme Court might be, making a decision. It's moot now because she's passed, so she doesn't have to recuse herself. But there is a code of judicial ethics, and I think that particular area in particular was problematic for her comments here. But I think that she probably felt sort of held back on some areas of society where she couldn't really speak out. And justices and judges can't really speak out on political issues. So that's one of the rights that they sort of give up when they take the bench. And she knew it.
Yeah, I agree with that. I think she knew exactly what she was doing and what backlash she would generate, and knew that she would be issuing an apology at an appropriate time. And I also agree that justices cannot and should not comment on political issues. I think it calls into question the independence of not only the individual, but of the institution as well. And I think that the independence and of the institution has come under question over the past 20 years significantly, beginning with Bush v. Gore, the decision that ended the Bush versus Gore election campaign. And I think that caused and was viewed as a political decision and politicization of the institution, and the recent nominations that have been so hotly contested and very partisan has only increased the view of the court as a political rather than an independent organization. So I think that there are good reasons and important reasons to be very conscious about those kinds of comments, and anything that would fuel thoughts of the institution as being a political institution, I think just should not be raised.
I concur with both of my colleagues. That was well put. Well put.
It's hard, I think, that society has become so cynical that right now it's very hard for us, I think, to see any answers that Barrett gave. It's just a very difficult time. I would like to circle back to the hearings, the nomination hearings. Senator Kamala Harris, she quoted Ginsburg during her spiel to Barrett, and during the nomination, she said that while, this is Harris speaking, while making it clear that she did not say how she would vote on Roe versus Wade, she definitely indicated that it was a woman's right to control her health decisions, her reproductive decisions, etc. Was this appropriate by Ginsburg because it let the Judiciary Committee know her views, or would you prefer Justice Barrett's attitude of the non-commenting on all such matters of policy and legislation in terms of her own opinion? Is it simply up to court members to know her voting record, public statements, etc., and then just not even bring it up during a nomination hearing? When we kind of touched on this, but it's really important, especially now.
I think that the responsibility of all the senators, especially those representing their respective states, was to ask questions, the hard questions that pertain to those states. I just read an article recently where it said that, especially as far as Roe versus Wade, that should Roe versus Wade come up again, and if there's a different decision, that 24 states and 3 territories would automatically they would not allow for abortions at all. And then there's 5 states that could go either way, and 21 other states with no question about it. So as a senator representing California, she needed to ask those questions for her constituents. As far as, like you said, we have talked about this a little bit. As far as Barrett was concerned, if I had been sitting there, I would have done the same thing. I would have stayed off that issue. I wouldn't have gone down that road. And Barrett did a great job as far as not allowing that to happen. But Barrett also knew something else, and that was, if I can just hold on just a little while longer, I'm gonna be through this. It's not gonna be like Kavanaugh. It's not gonna be like Thomas. It's gonna be over. They promised me that. And so she did what she needed to do.
Did you believe her? Because that's actually my question to the 3 of you, because we have touched on this before. So her answers were fine, but did you believe her?
We have to hold our opinion on what we think.
Uh-oh, he's going into preacher mode now.
Gerald, did you believe her? Because when I was listening to her, if I didn't know what I know, they were good answers.
But I know what I know.
Yeah.
So.
What about Paul and Marilee?
There's no doubt that she had been coached, and she knew to just use that as her mantra. And yeah, that's typically what all the nominees for justice do. It was striking that Justice Ginsburg was more open when she responded to the question related to Roe versus Wade. But that probably was because she felt that it was important to give her interpretation of the law. And of course, it to some extent represented her body of work anyway, so it was no shocking revelation. But you're right. If a nominee is going for this lifetime position, like it was said during the Kavanaugh process, they said, hey, he's going for a lifetime job. We should certainly know all about these people, and certainly knowing how they interpret the law seems perfectly relevant to me.
Mm-hmm. Mm-hmm. Paul?
Yeah, and I agree with the comment that this whole process has been a foregone conclusion, and the only thing that she could do is mess it up by speaking out of turn in some fashion. And but it is important for the reasons that Marilee suggested. This is a lifetime appointment, and so it's important to get those issues out on the table. Part of the question was, is it simply up to the Senate committee members to know the voting record, public comments, etc.? And I think the answer is yes, so that they can be brought up and she can be questioned. She can respond as she responds. Do we believe her? Well, that's up to each one of us. But the questionnaire, you can download it from the Senate Judiciary Committee website. Her questionnaire, her written response was 65 pages long. It also included 1,800 pages of documentation, including 150 speeches and writings for both academic and popular audiences, identified nearly 100 opinions that she has written, and over 800 appeals in which she has participated. So there's a body of work out there that can be brought to knowledge. She also, in her personal life, she says that she was walking out of church, she signed a card that says, we, the members of this community, agree that we oppose abortion from conception till birth. And so there are those kinds of personal statements that she has made. that are fair questions, and should be brought up so that people can have an understanding of, where she coming, what kind of person she is, where she's coming from, and reach their own conclusions, how that will affect, if at all, her approach to the law and these decisions.
Thank you. Jerry?
Right, for the next one. This is a good segue into this next question then, kind of comparing and contrasting the process for Justice Ginsburg and the recent process for Justice Barrett. Justice Ginsburg was confirmed on a 96-3 vote, and Justice Barrett was on completely partisan lines. So two parts of this, I guess. Number one is, with the way the process has changed in confirming Supreme Court justices, if you could re-engineer those, what would be a different way to structure the nominating process? And what would you like to see it to be?
But I guess the first thing I would like to see happen is, right now, the rules have changed at the Senate. All you need is a simple majority vote. I'd like to see it go back to 60 or 67 votes required to approve the nominee. I think that would go a long way to smoothing out some of the outer edges of people whose nominations come before the Senate. I think there would have to be a lot of agreement and a lot of smoothing out and smoothing down. So we're not going to get people at the edges. I think that would be the first thing I'd like to see. And the second, and this is something that actually the first George Bush proposed in 1992 after the hearings for Bork and Thomas. One of the things that he suggested was that hearings ought not be televised any longer, and the questioning ought to be limited to professional qualifications, and they ought to be done by, and this is kind of a new gloss on that, the questions ought to be proposed or propounded by the lawyers for the different, the majority and minority at the hearing, instead of by each senator. So I think just those couple of changes would go a long way to help, hopefully, improving the system.
They've also found that, especially with Kavanaugh and Barrett, that dark money has entered into this, that actually run ads without anyone really knowing where the money's coming from and who the donors are during the confirmation process. What can we do about that?
Well, I want to go back and ask Paul a question, and that is, if we get a new Senate, do you think they would be willing to go back, or do you think it's going to be payback? And the other thing is, having dealt with, especially in Arizona, ARS 39121, the public records, and the way that our media here, I mean, Arizona, like Florida, you can almost get anything. Do you really think that it's going to be that easy with CNN and Fox and the others to say, what do you mean not televised? The people have a right to hear this.
To your second question, no, I don't think that would be easy at all. I was surprised, having it come out in 1992 from the first President Bush, that sounded reasonable at that time. And then I was real surprised to see that it has been floated again, the idea of not having it televised. I agree. I think that'd be really difficult to do, but I think it's an interesting concept. With a new Democratic Senate, would it be payback time, or would they want to kind of smooth things over? Well, I don't know. There's been a lot of bad blood spilled, I think, in the Senate over the last few years, so it may go payback.
Well, on the topic of putting it out there for the public, I do think televising it's important because I think transparency is important, particularly in this society where everything is social media and everyone's accustomed to seeing the nominee having to answer questions. I don't mind if the questions are then asked by attorneys instead of, senators. That would be fine. But I do think it's important that we see the nominee and see how the nominee answers questions.
A lot of times people don't even know who the justices are. And, by it being televised, this would give them an opportunity to at least, find out something about them just as a citizen.
Thank you.
So, do you all think that RBG should have retired during the Obama administration so he could appoint her successor?
I have two words: Merrick Garland. Yeah. And I'm only being partly facetious because the Merrick Garland nomination occurred in the last year of the Obama presidency, but the Republicans controlled the Senate for the last 2 years of the presidency. So, when is the time? When is the right time to retire? I mean, you just don't know that, and there's no guarantee that you're going to get the result that you hope for. And who wants to lose another couple of years of Justice Ginsburg on the bench?
Yeah, she said there was no one like her to replace her. And she publicly stated that she planned to stay on the bench until age 90. It was no secret that she kept fighting different forms of cancer, but she also made it very public that she was, keeping herself physically fit, had her personal trainer and had her specialized program and, could lift more than a couple of the other justices. So she truly believed she'd make it in time, and she got mighty close. She was just months short of the election. So she made a gamble. She sort of lost, but at least we got more years of her. And again, she was ever so excellent.
She gave her all. She loved her work, and she did everything that she possibly could to stay mentally sound and physically whole. And you have to commend her for that.
You.
Absolutely. And so that speaks to the question of legacy, right? She obviously was a great justice, a great woman, great mother, person overall. And so when we talk about her legacy, what is the greater legacy in your opinion? The cases that she argued in the court, or the decisions that she made as a justice, and why?
I wrote out an answer for this one, and I guess it starts off with how I started to really recognize her in so many ways. She was the notorious RBG, and she may have been a great litigator, but the decisions that she wrote on the U.S. Supreme Court gave her an eternal image of accomplishment, long-standing documentation of her intelligence and her professionalism. And so I remember it was a couple of years ago when they first came out with Notorious RBG, and there were all these pictures on Facebook of these little girls that were dressed up like the justice. And I thought it was the highest tribute that you could pay to her, because it wasn't something where they were making fun of her, but it was more of, I want to be like her. And so I go back and say that the work that she did on the bench, the decisions that she wrote, the endless hours that she invested, that will be what we will always remember.
I agree. everything she did was very excellent, very fine, but I think the most long-lasting effect and greatest contribution were the both majority and dissents that she wrote while she was a justice.
And in terms of her long-lasting contributions and legacy, I think what she accomplished in terms of gender discrimination as a litigator and in part while she was a justice maybe have the most long-lasting effect. And simply because have been a number of controversial decisions that she was a part of, 5-4 decisions on the Supreme Court that I fear, may be in danger now. And so that's why I'm a little bit concerned that that some of the excellent work that she has done and accomplished in the Supreme Court, I fear that being undone. But I think the gender discrimination work is here to stay.
So as the leader of an interfaith network, we know there's great diversity in our faith traditions across the state and the country. And so I want to know, what impact does a justice's faith have on their approach to cases? RBG was Jewish, and the court will now have 6 Catholics. How do you think this impacts the diversity of decisions?
Well, ideally, a justice should approach each case in a neutral manner with analysis and following precedent and discussion with other justices. However, a justice is a human being who brings all of what he or she is to the task at hand, and it is concerning when there is a lack of diversity in any manner. So one example that Justice Ginsburg raised was that of lack of diversity before there were any women on the Supreme Court. So that's one example, but that's actually somewhat perhaps parallel to this faith inequity, so to speak, at this point in time. But bottom line is there's supposed to be separation of church and state, and the justices are supposed to be able to separate within themselves what their reasoning based upon the law versus what they might be feeling based upon their faith.
Yeah, I think looking at their faith affiliations and just looking at that, you might reach a conclusion about how things may end up all going the same way. But if you dig down a little bit deeper, I mean, I think how people's backgrounds and life stories affect things, also affect their point of view, also is important to how they approach the law. For example, look at Sonia Sotomayor and Clarence Thomas, both Roman Catholics, both had presumably different life stories than the white Roman Catholics on the court, and they end up on opposite ends of the spectrum on the court. So there's a lot going on. Having one group or a large group for the same denomination, I think that is something to look at. But for me, another issue of diversity is the law schools that the members of the court went to. 4 of them went to Harvard, 4 of them went to Yale. One of them, Justice Barrett, went to Notre Dame, but the other 4 were in that real tight East Coast Ivy League bubble, and I think that's another matter of diversity to be aware of and potentially concerned about.
I think that's a great point. One of the things that I was going to note was that, especially having been Catholic, all Catholics don't practice, all Catholics don't agree. but diversity is always something that is beneficial, because like Paul was saying, you can reach back on things that you've gone through, experiences that you've had, regardless of where you may have grown up or what religion you're supposed to be a part of, and be able to add to the decisions that come before the court. One of the things that I think about was a case that was out of Texas, and Justice Marshall was he was dissenting in the case, and I was in law school at the time, and his brethren couldn't believe that a person of the same background could discriminate against another person of the same background. Both of the individuals were Latino. And Marshall talked about the discrimination that comes with the darkness of one's skin and how lighter skinned individuals may hold that against them. And the majority just didn't get it. For those of us who were in law school that were African American and Latino, we got it. Mm-hmm. And so that diversity that you bring is critical for individuals to understand what those who are coming before the court are trying to get you to step in their shoes. I clerked for Judge Voss once, and one of the things that he said was, sometimes people just wanted to be able to tell their story to the person wearing the black robe. So that person wearing that black robe, hopefully, is non-biased and is willing to listen and to try to understand and apply the laws the best that they can to that situation.
I have a follow-up question to this. This would have to take, there would be a period of time, not just one case or two decisions, whatever. But if over a period of time, because of those 6 Catholics, the American public saw that there were rulings that seemed, ruling after ruling, decision after decision, that seemed to favor a Catholic manner of belief and thinking. Does the public have any recourse to say, wait a minute, we have a problem here on the diversity side, and we believe that it's going this way, and we want more diversity, and we don't have it? Does the public have any recourse, or are you stuck?
Well,
Bueller.
I'm gonna take a stab at this. One of the things that I guess I concur with as far as Biden, and it's because we have so much in the way of being politically concerned about who's on the bench, and 6-3, and now the Ginsburg is gone. That to have a commission to sit down and to evaluate it and to see where we are. 2 days ago, New York Times, they had a number of different articles. It was all under one. Where do we go from here? But one of the things that was real interesting was how they talked about how Congress can actually come up with a constitutional court to deal specifically with constitutional issues, pulling individuals from both parties, 4 on each side, so you never have one that's overriding the other as far as politics is concerned. And they would serve with term limits. And I tell you, I had never thought about anything like that. But they talked about how throughout history, they've set up other courts. Congress has set up courts in order to, even here, we look at in Arizona, veterans courts, where you wanted to try to address those issues because veterans they've been through something that non-veterans haven't been through, and they suffer from PTSD. But I think it would be interesting to take a look, and to report back. What would be in the best interest of America today, as far as our judicial system? It would fall right in place with everything else we're talking about, criminal justice reform. Let's take a look at it. Let's take a look at the courts as well. Because when I was chairing the Commission on Minorities for the Arizona Supreme Court, one of the things we asked for was that judges go through cultural awareness training. You would not believe the backlash we got from judges telling us we're judges. We're not biased. Like, okay. And Justice Blackett said they will go through it. It was probably one of the best things that ever happened because they got to a point whereby they had an opportunity to talk about things that they thought that they were not biased about.
Thank you. Well, actually, Billy's follow-up question was the perfect lead-in to our final formal question of this evening. And that is, there is some discussion out there about implementing court reforms, such things as the process. We've mentioned some of them tonight, possibly putting in some type of term limit instead of a lifetime appointment, things like that. We talked a little bit. What would be the impact of one of the proposed reforms of expanding the court? Or are you in favor of establishing term limits instead of lifetime appointments? Why or why not?
Understanding the Constitution says lifetime appointment. So if we wanted to change that, then it would take a constitutional amendment. In our current political climate, I'm not sure that we could get that through.
And I think that's a really good comment, and I agree with that. Unfortunately, I think that lifetime appointments are part of the problem and create a perpetual majority for a long period of time, and it's very difficult to undo that or to move on to a different direction. But I do support changes, providing term limits for judges, and for the reasons I suggested earlier, which was I think the court has become politicized for a lot of reasons. 20 years ago, before Bush v. Gore, I would not have supported term limits. Now I do, because the court has been politicized, and it's really hard to move off of that. The other part of the question was, what impact would we have of expanding the court? Well, it all depends on who's doing it and for what reasons. The Supreme Court of Arizona was expanded to solidify a conservative majority on that court, not to prevent the court from veering off in one direction or the other, rather to solidify the direction that it's going. And so expanding the United States Supreme Court depends on who's doing the expanding. If it's a second Trump administration, it would be to presumably add to the conservative majority on the court. If it's done by a Biden administration, it would be to moderate the conservative majority and make it more balanced and allow for more balanced decisions and keep it from going too far either to the left or the right. But it's one of those things, you think you've really got the wind behind your sails, and you've captured everything if you can expand the court. But guess what? It may take some time, but everything will switch back the other way. So
Right.
Be careful what you ask for.
Right. Well put. Well put.
Yeah, and in this whole discussion about expanding the court, and I know she said that was going to be the last question, but I just want to tag on a little bit more.
We have a little bit of time, so go ahead.
Yeah, as we talk about kind of social justice issues, the expansion of diversity in our country and society, and as we talk about reform in the courts and criminal justice system, how can we live out or live into the legacy of RGB in creating a space for more diversity, so that we actually do have more equal justice under the law for persons of color and communities of color? How is it that we can live into that legacy based upon where we are right now?
Khalif, let me ask you a question. Are you talking about living into that legacy and the diversity in the court based on race, based on gender, based on sexual orientation? What are you talking about? Because I can tell you, I've taught this class, and what I find over and over again, they say, well, if we put someone who is African American or Latino or a woman in, then that's going to help as far as changing it. And so often, when you go and you survey them, they aren't looking to upset the court, upset the cart.
The apple cart, yeah.
Right. They're looking to go ahead and be a good judge based on what they have before them. And if you don't have the laws in order to give them the flexibility, like Paul was talking earlier, in order to go up and down on that scale, and they're locked in, they're going to come across just like an individual that, you may see every day.
We talk about, even in the church world, we talk about diversity, right? If you want to be a reflection of the community, then you put diversity in your leadership, right? And in my opinion, the same is true of the courts of the land, right? Not just the Supreme Court, but all of the lower courts as well. Not that those persons should become scapegoats, but that they should be an equal voice into shaping, forming, constructing, writing, arguing the laws so that they do reflect a more diverse opinion, and that there is more equality under justice of the law for everyone, right? And whether that's race, gender, sexual orientation, all of the categories that you described, but more equal voice. It is said that, and I would have to check the facts on this, but that the Trump administration has appointed more justices to courts than any other administration in history. That is a specific viewpoint being added to our courts. How can we get to more diversity is the question, I think.
I'm looking
I
at
didn't
my
mean to
colleague.
stump. I didn't mean to stump y'all. I should have said that one earlier.
If you like, we could all sing the Jeopardy song. While
That
you're
one was
thinking
just off the
through.
cuff. I apologize.
No, let me share this with you. When
Yeah.
you are in a police department, paramilitary organization, where the majority of the individuals in there are white males, and you have various communities that you have to serve, one of the things that you have to do, it has to come from the top down. You have to take the time in order to educate. You have to take the time in order to make sure that you are doing follow-up as far as accountability, and making sure those individuals who are responsible are keeping everybody on track. And it's not an easy process. When I went to Salinas, California, and they asked me, as well as when I went down to Tampa, they said, how long will it take to have a community relations, a police community relations situation or setup like they do in Phoenix? And I told them it takes 15 years.
Mm-hmm.
You have to say, this is but what I'm hearing you say is that, okay, Trump brought all these people in. They came in with their ideologies. They came in, under the Republican umbrella, and we're all expecting them to follow this path. The thing about it is, we don't know everything about them. Those same individuals may have come from some very hard situations. They may be married to or have their children married to individuals from different cultures. And so they may have already started to learn. But you have to make sure that everybody's on the same page as far as teaching them what it is that you are looking for as far as judging. Not to tell them how to, the
Right.
decisions they have to make, but how to balance. That's just my opinion.
Do you guys think that because of the controversy, or however you want to frame it, with Barrett's process, nomination and then appointment, from a civics class point of view, do you think, and earlier you mentioned not everybody even knows who all the justices are. Do you think this raised the awareness of the American public that we should have an interest in the Supreme Court? We should pay attention, more than, say, even Kavanaugh's nomination or his predecessors? Or was this kind of same old, same old?
That's why we need the transparency.
Yeah.
Yeah, I think it's not the same old, same old. I think it's
Agreed.
we are all being taught to be scared of the Supreme Court, no matter what side you're on, as opposed to respecting it and accepting the decisions as being independent and simply based on the law. We are being taught, no, that's not how they act, and it's a political institution, and we have to be scared of its decisions.
It'll be interesting to see if anybody decides to address that very thing.
Bill, since you raised that as a follow-up, you know, a lot of people don't know who the justices are, really don't understand the court, let alone remember 8th grade civics class about what the role of the Supreme Court should be. Would you advocate for having the oral arguments televised on like C-SPAN or something? So again, because right now, you know, arguments still aren't broadcast.
Sorry, is that for me?
Well, I was going to let you follow up, but I certainly want to hear the opinions of Richard and Marilee too.
Go ahead, Marilee.
I thought that was for Paul.
Any of the three of you, go ahead.
Yeah.
Well,
Is Paul frozen?
I'll answer. Yeah, I agree. I think arguments ought to be televised. People ought to have access to that. Absolutely.
And I agree. Back to the idea of the people have a right to know. Those are important cases because they've been selected. The U.S. Supreme Court doesn't have to hear all cases. They only choose the ones that are important. So the American public should be able to see the oral arguments for those important cases.
And I guess for me, I would like for it to happen so that we can have young people become more interested in becoming lawyers and judges. And they need that exposure. They need to believe that, you know, I can do it even though I didn't go to Harvard or Yale. Maybe I went to Arizona State University. They need to see it. Why are you laughing, Billy? Why?
Katie, because Katie's gone.
I didn't even go to ASU, but I love ASU.
You know, you brought, and I know we're running short on time here, but Justice Barrett actually brought up about process and the whole piece, you know, for a case making it to the Supreme Court, and that they have far, you know, more cases than are actually put on their dockets. How are those cases chosen? Because is there an objective mapping of that, or is it subjective, basically? Because that's where things like Catholicism and all the rest of it will enter into it, as to what cases make it to them. Marilee?
Obviously, they can bring their subjective opinions to that selection.
So there's no roadmap of how cases get to their desk?
Correct. I mean, they have procedural approaches to how the cases are reviewed when they come up, but it starts with their clerks. But certainly, when they choose, it has to be somewhat subjective. There's no like objective criteria for, you know, this many cases in constitutional law and this many cases in water law. You know, there's nothing like that. It's just what they think is important at the time. And if they don't want to deal with the matter, they don't have to.
Great.
Well, yeah, sometimes they wait for a good case, or one that really hones the issues on a particular matter, presents the issues the way they want to see them presented, so they can get a really good decision.
Right.
Well, on that happy note, Katie?
Yeah. So as we are wrapping up our evening, remembering Justice Ruth Bader Ginsburg's legacy, I wanted to ask very quickly, will each of you, including our other hosts and MCs here, tell me, what are you gonna carry with you? What about her legacy is gonna stay with you as we move on and remember her? Just one sentence, very short.
I can easily start with that. She was a warrior, and I will carry that with me forever. Resist.
I think Gerald said she was only, 5 foot tall and 100 pounds, but it truly was a powerful intellect. And that's the legacy I will remember her for.
I'll always remember that she never forgot where she came from, and she took it with her wherever she went.
Similar to what Billy said, I will remember her as a fighter for justice for all.
I see her as a role model for all.
Yeah, and I would say the strength of character, integrity, and as a justice warrior as well.
As we depart today, I'd like to lift us up in a closing prayer, coming just from an interfaith perspective, knowing that we come together from different faith traditions as different people from across this country and across this great state, remembering RBG. So let us pray together. Oh, holy and holies. Every once in a while, you give us an embodiment of your love, of your justice, such as Justice Ruth Bader Ginsburg. We are so grateful for her life, her impact, and her legacy, and the gifts she gave to us while here on this earth. And we raise her up tonight knowing that she is now at peace and resting. God, we are grateful for the one who was here, who taught us to stand up for your justice, your love, and most importantly, all your people, no matter what. May RBG's legacy teach us to be notorious ourselves, notorious seekers of your justice, notorious enactors of your love, and notorious people working together to build your peace in a world that is aching for it. May we use her to help guide us, working together to bring about unity, the unity we are taught and brought together for. Amen. We are very grateful for all of our speakers tonight and all of our hosts. Thank you, Paul and Pastor Gerald and Marilee and Jerry and Reverend Khalif and Billy for your time today, and all of those that are on Facebook watching this live or on the UMC's website watching this live, and for those that see this later as well. We hope you will share this time together in this video as a tribute to RBG. So thank you all.
Thank you.
Have a great
Thanks, Christy.
Good night.